I just want to say to you that, the only reason I'm tolerating what you're doing to me is really for the interest of the client. Otherwise, you're not entitled to abuse me like you're abusing me. I'm senior to you in many ways, not just in age, but in many ways, you know it. So you have no right to abuse me. But fine, you've got the power now. You can exercise it, but you'll pay one day. Yeah. But anyway, I was saying, Chairperson, that Pardon?
Threatening me now.
Yeah.
Okay. All right. Please conclude what you want to say and attend to that. I will make a ruling.
No, it's not. Actually, it's not a threat, as I said. It's a promise. Yeah.
Okay.
What Advocate Dali Mpofu is trying to say is that the inquiry chairperson is supposed to be a neutral person, and Parliament issuing that particular statement that supports the Concord ruling, by extension, it means that the inquiry itself, which is chaired by this chairperson, Mr. Kurutile Jaji, then means that the process that they are embarking on at the moment is supposed to be a neutral and impartial process. But he's saying that that particular statement then means that this process of the inquiry is now not being reasonable and is not fair. And he's saying in his own words, and I quote him, it's a pipe dream that they think this is going to be a neutral process. Hence, they are now saying that in future, they may come with an application that calls for the recusal as well, or the removal of the chairperson. Now, again, the chairperson, in his response to this particular move by the legal team of the public protector, is saying is noted that particular a threat, or let's say intention, but he's not going to make a ruling now. He'll make a ruling with due course, and as the proceedings as we speak are underway, and as we sit now, quiet break.
Now, the High Court of South Africa Western Cape Division has, among other issues, ordered that the President's decision to suspend Public Protector Advocate Busisiwe Mkhwebane be declared invalid. Now, the suspension of Mkhwebane was subsequently set aside effectively from Friday, 9 September 2022. This comes after Mkhwebane launched an application in the High Court for orders declaring certain conduct and or decisions of the Speaker of the National Assembly, the chairperson of the Section 194 Committee, and the President of the Republic of South Africa irrational, unconstitutional and invalid. Mkhwebane was suspended in June and is currently participating in a hearing which seeks to look into her fitness to hold office.
Firstly, this is a clear indication that this process has got a clear mandate and a clear objective, which is to find Advocate Mkhwebane guilty, find Advocate Mkhwebane incompetent. Therefore, if anyone wants to push for a fair process, to push for an objective process, to push for an objective and fair inquiry, that person will be victimized. I myself have been a victim of how the chairperson has thrown me out of a meeting just by merely stating that he can't be telling other members to address them for as long as they want, but when I am addressing the committee, he limits me to an hour. So what happened yesterday was a clear sign that that chairperson of that committee is biased. That chairperson of that committee has got a clear outcome and is going to do whatever it is in his power to make sure that the committee goes as directed to the outcome that he wants, which is to find Advocate Mkhwebane, incompetent. Yesterday, the Advocate Mpofu raised a point of order just before the evidence leader spoke, and the chairperson said, I'm going to allow you to address after he's spoken. Now, when the evidence leader was done speaking, Advocate Mpofu was addressing that point of order. The chairperson was, you're not going to speak about those things, you are just going to speak about what I'm asking you to say. And when Advocate Mpofu is reminding him about the point of order that the chairperson has said is going to allow him to speak, the chairperson would not allow any person, to actually hear.
Advocate Dali Mpofu refuses to participate in what he calls an illegality. Of course, this was part of the proceedings today, as there were various arguments about whether or not this matter should be adjourned.
as I say, in any event, beyond the mandate that we were asked to perform today. So I'm afraid then, as far as the legal team is concerned, at least that will be as far as we can take it. And good luck. We'll see you again, maybe, or maybe not.
Let me do this then so that I get much clarity. So are you indicating that you are electing not to do cross-examination tomorrow, nor being part of the process of the evidence leaders leading evidence of the next witness? I need that to be clear. And is that what the public protector say?
No, the public protector will speak for herself. In fact, once I finish speaking here now, she can only speak for herself.
I think, for correction, Chair, I didn't say, or I didn't give a mandate to my legal team to. Yes, so I think that's what they've discussed with the attorneys, and for now I'm not in a position to. I'll have to discuss with them because we didn't discuss the continuation of the process, because the issue was for them to apply for this process. So I will have to go back and discuss with them, or alternatively, if they decide to withdraw, especially the attorney of record, then I'll have to find a way of finding an attorney who will have to proceed with the matter, or as well alternatively convince the current legal team.